Good morning, good evening, good afternoon. Welcome to Audit the Audit Chicken Edition. I apologize for the jerry-rigged attempt to get chat on the screen. We all deal with the situations we have to deal with, so there you go. So I've audited Audit the Audit twice in the past. This is going to be the third time. Jeez Louise. Maybe I picked a bad time to start because this chicken did not start making the egg laying sound until I started recording or streaming. Anyway, so I've audited his audits of audits twice, and both times he was retarded. If I had something to throw, I'd throw it. There's only chicken poop on the ground to throw. Stick. Get out of here. This is where a dog that chased chickens would be useful to have chase the chickens away from me. So anyway, Audit the Audit is pretty fucking stupid. Just want to say that. The interesting thing is that he uses a symbol that looks like a justice symbol. But he's not an attorney. It's pretty obvious he's not an attorney. You could be pretty fucking stupid and be an attorney, but this guy's really fucking stupid. So what he did is he took Rusty's video. This is Tina and Rusty M. He took an hour and 40-minute long video. The long and the short of it is over the hour and a half, approximately. Rusty gets pulled over. He admits to having a prior DUI for methamphetamines. There's a reason why there's two troopers on a stop. If someone pulls you over, if a cop pulls you over for a cracked windshield, let me just say, if a cop pulls you over for a cracked windshield, another cop won't respond unless shit's getting, a little fun. Unless things are about to get spicy, right? So anytime a second trooper pulls up, there's your sign. There's your indication that shit has gone awry. Now, legally speaking, where we're at is it was this case right here. He was found guilty, or excuse me, his license was revoked, not found guilty. This is a civil matter, at least in this state, and he after trial with full transcript. And after a trial where they had the state, I guess, file or here's the order denying, right? The respondent, which would be the state, or the Commissioner of Public Safety, filed a memorandum in support of sustaining revocation. The Rusty was represented by Anthony, something starts with a B, Anthony Busa, who filed a trial brief. But at the end of the day, and this is the petition that Rusty filed to get his license back. So at the end of the day, the state prevailed. Rusty was not able to prevail. The case has been appealed. Arguments have already been made in the appeal. And I'm telling you this because you guys kind of need a bit of an understanding of where we're at, right? So basically, it is uncontroverted that Rusty was driving under the influence of Adderall. That's not controverted at all, right? He was driving under the influence of Adderall. His defense was that he was driving under the influence of Adderall with a prescription. He was taking the prescription according to the prescription. He was taking the Adderall according to a prescription. And that the amount of Adderall he was taking did not impair his ability to drive. That's his defense, which if he could prove those things, would be sufficient in Minnesota to allow him to keep his license, right? So, just so that you're aware, having read the transcript, the only thing it was done remotely. So the only thing that Busa submitted was Rusty's medication lists printout from the Trum drug pharmacy out of Elbow Lake. So he is not provided as an exhibit. He's not provided an expert witness statement, any reports. He has not provided the actual prescription. He hasn't provided anything. He just, that's all I gave was the list of medications that he was on. Don't know why he did that. Zero knowledge of why he did that. Was that his attorney fucking up? Probably. Go behind the blue line. I would invite you up here, go behind the blue line, because you are, of course, a peace officer, and I didn't get any bites on my Minnesota peace officer deal, or a toxicologist / pharmacological scientist or whatever. Well, Eddie, you're pretty fucking stupid, and you should probably shut your fucking pie hole before you make yourself look even more stupid. Sorry, not sorry. So yeah, so Rusty has a job, by the way, as a CDL driver, right? So he drives for a living. Not only does he drive for a living, but he has 2 DUIs. He had one in 2003 that doesn't show up on his list of convictions. But he has a DUI in 2021. A DUI conviction in 2021. Why don't I see it? There you go. I guess it was filed in 2020, but the conviction was in 2021. There you go. So he was driving in 2019. That's when he got caught. He was convicted in 2021 of DUI for a Schedule 1 or 2 drug driving, right? So that's one. And then according to the transcript, in 2003, he was convicted in Crow something or the other county. What was it? Crow County? He also got a disorderly conduct. Crow Wing County. So in 2003, he was convicted in Crow Wing County. It doesn't show up on this, but apparently it shows up in his normal record, or in the record that the state has access to. That there was a DUI for alcohol in 2003. So this is his 3rd DUI. I am shocked, having been in the LTL industry. I am shocked that someone could get a job as a CDL driver, especially with hazmat endorsements, after having 2 DUIs. But this was his 3rd, right? And you can see a long line of things. Restitution judgment, I'm assuming that has to do with restitution for criminal activity. 3rd-degree burglary, these two may be related. This one is another burglary, 3rd degree, convicted. I mean, the dude has a long record. Another burglary, 3rd degree, convicted, that he was convicted of. A disorderly conduct that he was convicted of. Loitering that he was convicted of. Apparently they tried to get him on disorderly, but they couldn't. Driving after suspended license. Driving after suspended license. I don't know why this was in here. Oh yeah, because I'm showing the civil cases because the traffic one is a civil case. Convicted of disorderly conduct in 2014. Convicted of operating a vehicle without expired or with expired registration. Convicted of, this was the DUI or DWI for the meth. Careless driving convicted in 2021. Disorderly conduct, another conviction in 2021. Convicted domestic assault he was convicted in 2023 for domestic assault. And then this would have been, I think, after the offense date was 8/4. I think this was, so I think after he lost his license for this one. Did they establish the date of the, Yeah, so May 31 is the date that he got pulled over. So because he got pulled over for DWI, they suspend. Well, and it came back positive because of that. His license was suspended. So this one right here, he was speeding and driving on a suspended license. It's like, so this is the kind of guy we're dealing with, right? This is the kind of guy we're dealing with. Nevea, heaven, backwards, whatever. Would that be hell? I don't know. So someone certified as a DRE isn't a DRE just because they took a 6-hour class either. Yeah, so it's, I think, so she testified it was like a week-and-a-half class. She went to Sacramento, California. Woo! Shout out to Sacramento, where they got to deal with people who were actively impaired. And apparently every once a week she does a or not once a week, once a year they do a continuing education class somewhere around the state of Minnesota. This is water, by the way. Water with a little bit, actually a lot of it, of lemon juice in it. So don't get too excited. Don't expect me to get drunk. It's way too early to get drunk. And I got Vespers tonight, so you gotta stay sober for that. You know what I'm saying? All right, so I kind of wiffle waffling. Like, do we actually want to watch the entire Audit the Audit thing? I guess we'll do it. We'll punch into it. We'll give the context that he doesn't give. But let's look at the title. It says cops ruined his life over nothing in all caps. Well, Rusty doesn't contend that he had Adderall in his system, right? He doesn't contend that. He just says that he wasn't driving erratically. Well, someone called him in for driving erratically and actually swerving outside of the lines. Now, I don't know about you, but I don't think that gets called in very often just randomly as a prank. Let's just go with that. I don't think it gets called in randomly as a prank. So she testified in the transcript that for the trial that it's once a year they meet up and do, I think it's just like a 1-day kind of refresher course. I don't think I don't know that they do too much extra beyond that. So it was like a week or a week and a half, if I remember correctly, that she spent training to get it. And then every like a continuing education, right? So again, I'm wiffle waffling over watching this, but I guess we'll watch this.
Officer with the Little Falls Police Department in Morrison County, Minnesota, in response to a driving complaint from a caller who claimed that a vehicle with Mr. Moore's license plate was, quote unquote, all over the road. Trooper Megan.
All the stock photography or stock clips that they put in, like, why? Like, this doesn't make it, like, this adds nothing to it. That little stock clip added nothing to it.
Bozer, a drug recognition evaluator with the Minnesota State Patrol, responded to the scene after Mr. Moore was pulled over. And the interaction.
So here's a fun question for Audit the Audit. Are you a drug recognition evaluator? What are your qualifications to say whether or not the Miss Rusty passed the test or not. What are your qualifications? Do you have any qualifications? And there's a mosquito. Damn it. There's like at least 6 different kinds of mosquitoes in the area I live in, and man, they're vicious. They're vicious little bastards. You could tell the time of year, the season, by which mosquito is out and about.
And that followed was captured on Trooper Bozer's body camera.
And I got to be honest with you, Trooper Bozo is very professional the entire time. I mean, you'll see it. Like, she's very professional. She's polite. She's not aggressive. She doesn't physically harm him in any way. I mean, she gives him every opportunity to make good decisions. And thankfully, during this encounter, he makes good decisions. You know, I don't like to see people hurt. But this cop was, I think, incredibly professional.
How are you?
I'm good. How are you?
Good. I come in this way because I didn't want to be on the road.
Oh, okay.
Okay, I'm just gonna go talk to my partner up here. You good?
Yeah, I'm good.
Everything? Okay.
Yeah.
You just hang tight, okay? Can I just see his deal? Yeah, he's very. Yeah.
So the other cop just said he's and implying like it's hard to tell, but he's he's impaired, and she's already noticed it. Yeah, he's impaired, right? So right out of the gate, he's impaired. Like, they see it. Now, you may not see it, and I certainly don't see it, because I'm not a drug recognition expert. So what would have been helpful would have been for Rusty's attorney, to have presented some sort of an expert at the trial to say, oh yeah, so in watching the video, I don't see anything that the trooper could rely on to show it. Oh, MSG retired would also have been a great. Why didn't, dude? You would have been great to have up here. But anyway, MSG retired. I'll keep an eye on the chat. If you see something that that kind of makes you think that this trooper was wrong in her drug recognition evaluation, that things she's not seeing, you know, are not. Or whatever, you know, if you think that she's wrong in her assessment, that'd be great to know. Because quite honestly, I don't have I'm not an expert. All I know is that Rusty and or his attorney screwed up by not presenting an expert to show that this cop was wrong.
I see that.
Coming from Wadena,
Coming from Wadena?
going to his daughter's graduation.
But yeah, that's totally up to you.
Yeah, it's fine with me. I get off.
So what was cut out there is the male cop is the one who pulled him over, who is also a DRE, by the way. So right now you have 2 DREs. In the transcript, the testimony is that this guy who pulled over the driver was a DRE. But apparently his shift was ending, and so he gave this stop to her because she's also a DRE. But you have 2 DRE officers, not one, but 2. Not one, but 2. Say, but they both instantly are like, this guy's amped up. This guy's on some sort of I'm really topping out here. I'm going to tag this down a little bit. Hopefully that'll get me less spikes. But they're both instantly noticing that this guy is amped up. This guy is on something that's a stimulant. They both notice it instantly. Does the audit notice that? No, he doesn't, because he's not fucking qualified. He's not qualified to be a cop. He's not qualified to be an attorney. He's barely qualified to make videos on the internet.
Yeah, do you just want to hang tight just behind him? Okay. So I don't know if did you have your proof of insurance?
Yep. Would you like to see it too?
Yes, please. Yeah, so.
Is it okay to open it up?
Absolutely. You don't have any knives left?
See how you know, he is talking fast. He is doing things fast. I don't know. I don't know.
No. Guns or anything in there?
No, guns in it.
Yes, that's just fine. Where are you coming from?
Alexandria, just got off work on my way to my daughter's graduation.
Alexandria?
Yeah.
High school graduation?
Yep.
And you own the car?
Yep, I sure do.
Okay. What were you doing in Alec?
I work there for Mark Lee.
For what?
Mark Lee Asphalt. I drive a semi-dump truck.
Gotcha.
Just got work.
What were you doing while driving? Were you on your phone or something while
I got
driving?
hands-free.
Well, you were called in for being all over the road.
Yeah, that don't make no sense to me at all.
Okay, there's no reason that you would have been...
All over the road, or it was never all over the road. Somebody must be Josh and It must be a prank or something. I don't know.
I don't know about that.
Yeah, I haven't been all over the road and had no issue, so.
Okay. Are you taking any prescription medications?
I take Adderall.
When's the last time we took Adderall?
6 o'clock this morning.
How many milligrams is that?
30.
30. Okay. Once a day.
Once a day.
6. How about anything else?
No.
Any illegal controlled substance uses
No.
that we use? How about alcohol?
No.
Okay. So I'm a drug recognition evaluator, and there's a couple concerning things.
Okay.
I'm going to run you through a few tests.
Okay.
Your eyes are glassy, watery. Your driving conduct's being called in. I'm going to run you through some tests and make sure you're good to go.
So just so you know, the cops can rely in Minnesota. Cops can rely on anonymous calls. If someone calls something in, cops can rely on that as part of the evidence that they use to make the stop. And the rationale is apparently that because the person has given sufficient information that they could be held legally responsible for any false calls, then there's kind of a presumption that it's somewhat reliable, right? Joseph Snable's in here and very upset. He's upset he's spaghetti.
Okay.
Any questions with that?
No.
Trooper Bozer informs Mr. Moore that she's going to perform field sobriety tests, or FSTs, on him, and he agrees. Although she did not phrase her statement as a request, under Minnesota law, field sobriety testing is optional, and drivers who are suspected of DWI are not legally required to perform field sobriety tests. Notably, though, in the 2019 case of Otto versus Commissioner of Public Safety, the Court of Appeals of Minnesota determined that law enforcement officers are under no legal duty to inform drivers that both field sobriety tests and preliminary breath tests are optional. Accordingly, a court would likely determine that Trooper Bozer's quote-unquote request that Mr. Moore participate in sobriety testing was lawful, even though she did not inform him that he had the right to refuse.
If you want to, you can shut your...
Right. What he's not telling you is that if you do refuse, the cops can still use that. They could use that refusal as part of their probable cause analysis. They can. Now, I am not saying that you should agree to do any field sobriety tests. If you've been drinking or if you're under the influence of something, I would suggest you probably should not. If your state allows you to refuse to do the field sobriety test. There's never a reason to give the police more evidence to convict you. But if you haven't been using any illegal substances or any substances that impair your ability to drive, if you're on a prescription for something that might be impairing your ability to drive, maybe you refuse. But if you're sober, if you're actually sober, then I don't necessarily see why. Paige says some states you automatically lose your license if you refuse. I know that states will, like for the chemical tests, like blood draws, or some states the blow test. Some states will do that. I'm not sure of any that require you to do the field sobriety test where you touch your nose and put your head back and all sorts of fun stuff. And I think the reason why is that those are more subjective than objective tests. So, but remember, this guy's looking at his third DUI, and he's a CDL truck driver. If you don't have a license, you don't have a job.
Your car off.
Oh, I'm not late for my daughter's graduation.
What time's that at?
7 o'clock.
Okay. Hopefully not.
I still got to change into some clean clothes.
You don't want to wear that?
No.
Okay, hands up. Do you wear any knives or anything?
No.
Okay, I just quick pat because sometimes that's totally fine. People forget that they have pocket knives, especially if they do construction. I'm gonna have you come back towards
I work 15 hours a day, so.
Okay. So what time do you start this morning?
At 6 o'clock.
You started at 6?
Yeah.
I'm gonna have you stand in front of my grill here,
Okay.
face your car.
Okay.
Any recent brain injuries?
No.
Concussions?
No.
Tumors?
No.
That you know of? Any lower body injuries that prevent you from walking? Or
No.
I won't have you doing any cartwheels, so you...
So she's clarified with him. She's clarified with him at that point that he has no restrictions on doing any of these tests. A, he's done the tests before, and B, he just said, I don't have any restrictions on it. One of the fun facts that Rusty's attorney brings up at trial, and again he brings it up at the appeal in the oral arguments, is he brings up that he says that in here Rusty states that he has diabetes and that gives him neuropathy, and that the shoes that he's wearing are to correct for the issues that he has with neuropathy and diabetes in his feet, right? And which is odd because nowhere in here I've watched both Rusty's the full body cam, and I've watched at least parts of Audit the Audit's video, and I don't see where he he does mention his diabetes in here, but he never once says that he has some sort of a condition that prevents him from doing it. In fact, when he fails, or when he falls, or almost falls on the raised foot test, he says that the shoes are so thick and cushiony that he feels like he's on a boat. He doesn't. He never brings up his neuropathy.
Okay. Blind in either eye?
No.
Do you wear contacts?
No.
Okay. Just a couple questions I ask. Have you done field sobriety before?
Yep.
Okay, so
So Joseph is doing a fun little game I like to call substitute the exception for the rule. Now, he says, does Merv even know how many innocent people the THP, I don't know, Tennessee Highway Patrol, I guess? I don't know what that is, but I'm assuming some police department, has arrested for DUI over the last 4 years? I'll save everyone there. Well, so there's, first of all, you don't get found innocent. You get found not guilty. So that's number one. You're really fucking dumb there. You know, you're showing us how fucking dumb you are. But number two, the failure to convict does not mean you're innocent. And number three, how many successful convictions do they get? How many successful convictions do they get, Joseph? Why are you showing me the exception to the rule rather than the rule? You know, ham sandwiches are deadly. Do you know how many people die choking on ham sandwiches every year, Joseph? Well, I mean, you know, do you know how many ham sandwiches are eaten every year where people don't die from the ham sandwich? You're fucking stupid, and you're showing it. So congratulations. I love it. I love giving people the opportunity to show how fucking dumb they are. I mean, it never ceases to amaze me how willing people are to be like, yeah, I'm really fucking stupid, and let me prove it to you.
I may do stuff very similar, but I also might do it a little different from the past. I'll explain everything.
Okay.
So you won't be guessing. If you have questions, just ask. Okay. First thing I do is I just take a pulse. Yep, and just relax there. What was I gonna say? What was I gonna say?
Trooper Bozer takes Mr. Moore's pulse and...
Oh, okay. So just so you know, there's the only testimony in there is that the pulse was 116, and a normal person's pulse is between 60 and 90, right? So he starts off 1.5 to 2 times the normal beats per minute using rough math. So his pulse is elevated. Now, I don't know if that's normal or not. The troopers testifying that 600, he's talking about the scam in Tennessee where 600 people falsely charged and convicted until it was brought to light. But how many people were rightfully charged and rightfully convicted? You don't know. So bring me those numbers. Let's see what percentage we're talking about. You know, that whole per capita. Do stupid people understand per capita? So the trooper testified it was 60 to 90 is the average. What is an elevated heart rate? Is there an expert who came? Did the defense bring an expert to testify what it should be in that situation? Right? What it should be. Eddie Kale, your rate is anecdotal. Like that's not enough to know. But she's saying 60 to 90 is the average. I don't know if what she's saying there is the average for a traffic stop, which I'm assuming does quite a bit of, or if it's the average for resting heart rate in a non-stressful situation. But nobody brought an expert at trial, nobody brought an expert to show her wrong. Nobody brought an expert to say that this is what his should have been. Mountain mover with the incredibly high IQ take of one innocent person being arrested is an issue. No, innocent people get arrested all the time. It's whether or not you have probable cause. So you're fucking dumb and wrong there. It's not about whether or not you're innocent. It's about whether the cop has probable cause. Cops are allowed to make arrests if they have probable cause. They could arrest an innocent person if they have probable cause that that innocent person has committed a crime. Jesus, stupid people are stupid.
And later testified that it was 116 beats per minute, which is higher than the average resting pulse rate of 60 to 90 beats per minute. Now, although an elevated...
hold on a second.
Testified that it was 116 beats per minute, which is higher than...
So he's going to say that it's higher than the average person's resting heart rate. Resting. Where in here did she say resting? She didn't. She did not. She said the average person's pulse is between 60 to 90 beats per minute. Is that in this situation or is that resting? I don't know. You don't know. No cross-examination of her illuminated what she was trying to bring to light. So we don't know. So this again is highlighting the failure of Rusty's attorney. So some questions that we have that haven't like, there was no expert brought to give an alternate explanation for the facts, to explain the facts in Rusty's favor. No prescription was presented. No testimony was adduced at trial saying that the amount of amphetamine detected in his blood at 6:30 at night when they did the blood draw. Was it 6:30 at night, or was it almost? It was almost 7 o'clock. It was like 6:50 at night. It was almost 7 o'clock. There was no testimony that the amount of the 0.034 milligrams per liter or whatever it was in his bloodstream was consistent with him taking 30 milligrams in the morning at 6 a.m. or was it excessive? We don't know. We just don't know. So this is a failure of evidence. And the question I would have would be if his attorney actually sought out an expert to testify about what the appropriate amount of milligrams per liter of amphetamine in his system 13 hours after he took it or so, is that the appropriate amount? So was it a failure to get the expert, or perhaps did he get an expert? Did he actually seek out that expert advice, that expert testimony, and the experts came back with, no, that's more consistent with a man of his size and weight having taken a bump of, a crushed up half a pill, 30 minutes before, or whatever, an hour before the test or something like that. So we don't know. So am I saying that Rusty actually abused amphetamines? I'm not saying that at all. I don't know. I mean, there's a complete failure here. But he was convicted of it. He absolutely was convicted of it. And whether or not he was convicted based on his attorney's failure to present evidence that was exculpatory, or whether it was the fact that his attorney found these experts and the experts said basically that Rusty was fucked and this was just a Hail Mary to see if he could prevent the DUI from taking. I don't know. So I hope that explains it. Like, people in here, like the stupid people, the really fucking knuckle dragging stupid people in here. Well, if all she relied on was the resting heart rate, if that was all she relied on, that might be a thing. But in her testimony, she goes over a wide variety of things. He was showing dry mouth. Yeah, his tongue was white and it was dry mouth. The previous DUI, that is evidence. It was 130 later on, after he performed some tests. The glassy eyes, the bloodshot eyes, fidgeting, failure to remember commands. I mean, she goes through a litany of things that she sees that there's no expert presented to counter. They swallows the boot hardcore. Oh, Jesus fucking Christ! What an amazing insult, Samuel. I'm oof. How will I ever live that one down? And then Mountain Mover, because he's a fucking retard, thinks that the Fourth Amendment prevents these sort of tests. You give implied consent, maybe even express consent, but you give consent when you operate a vehicle with a driver's license to these tests. So, yeah. So, oopsie fucking doodle. Oopsie fucking doodle. The Fourth Amendment doesn't apply because you've consented to it. This has been hashed out a lot. You just don't know what the fuck you're talking about.
Than the average resting pulse rate of 60 to 90 beats per minute. Now, although an elevated heart rate is a
So again, he assumes it's a resting heart rate, but he doesn't know. So this is just another failure on Audit the Audit's part.
Documented physiological effect of stimulant drugs, including amphetamines such as Adderall.
And he goes to Wikipedia. Congratulations on your Wikipedia-ing.
High heart rate is not exclusive to stimulant impairment. For instance, the Mayo Clinic notes that exercise or emotional stress can produce what's called sinus tachycardia, a normal rapid heart.
You know what would have been great, though, Audit the Audit? It would have been great if Rusty's attorney had presented an expert who could testify to this stuff. Wouldn't that be amazing?
Heart rate in otherwise healthy individuals. As stress, fear, and anxiety trigger adrenaline release that elevates the pulse, and being stopped by police is often an anxiety-provoking event, the surge of adrenaline can cause a racing heart and jitteriness that mimic drug
All of these clips are just really adding to it.
effects. Therefore, Mr. Moore's elevated heart rate alone would likely be insufficient evidence to prove that.
Yeah, that's a good point. His elevated heart rate alone. What else? What else did they have?
He was impaired.
So next test, it's a Romberg test. So
Okay.
feet completely together,
Okay.
toes touching, arms by your side. You're gonna tilt your head back and you're gonna close your eyes.
Okay.
While you do that, you're gonna estimate the passage of 30 seconds.
Okay.
When you believe 30 seconds has passed, you're gonna tilt your head down just like you are now and open your eyes and say stop.
Okay.
So I tell you when to start and you're gonna tell me when to stop.
Okay. Eyes open, closed.
Eyes closed.
Okay.
Yep.
Okay.
She's doing these tests with him.
Yep. You can begin.
Finished.
How'd you get there?
Well, so what he did here is he cut out the actual test. Now the officer testifies that during that test, he was swaying, his hands were fidgeting, and there was something else. She says, throughout and after every explanation of the instructions, Mr. Moore would respond, okay, as if he was understanding. I again asked him prior to telling him to begin the test if he asked and understood all the instructions. He said he did. When I was about to begin the test, he then began asking questions about the instructions. I would then re-explain portions of the test. I told him to begin the test. Throughout the administration of the test, or the estimation of the passage of time, he continued to have uncontrollable body movements. His hands would begin twitching. He was swaying while balancing. He had visible bruxism, which is the grinding or the clenching of the jaw. All of these are very common among individuals who are impaired by a stimulant. So by editing this as he did, he fails to show you, the viewer, what was going on. He's focusing on the amount of time that passed. Well, the next question is, how did Rusty estimate 30 seconds?
What do you mean?
How'd you get to 30? Did you count? Did you just guess? I just asked?
Yeah.
Counted in your head?
Count in my head. Was I close?
You're close.
Okay.
So that inability to say just like, how did you get there? I counted, right? Why was he unable to respond until she gave him options, right?
You'd be surprised what the answers I get.
Okay.
So you're a little taller than I am, so I'm gonna have you have a seat on this chair. Well, I shouldn't say chair, but it'll be your chair for this.
Trooper Bozer performs a series of field sobriety tests.
So Eddie says if someone truly has ADD or ADHD, like I do, you don't fidget. You're calm as hell. I don't know. I work with an attorney who has some pretty severe ADHD. He takes, I think, like 120 milligrams of Adderall or something like that a day. He takes a lot. And he's still a little fidgety. Not too bad, but a little fidgety. So
Tests on Mr. Moore, including a horizontal gaze nystagmus test, the walk and turn test, and the one-leg stand test. Mr. Moore
well, so again, by not showing us these tests, we can't determine what he did or didn't pass. The next step was the horizontal gaze nystagmus test. He passed that test. She didn't see any clues of HGN, but she would not have expected to see it, right? So all of that did is it ruled out other signs of impairment. So she used that. They do these tests. Each test kind of allows them to look for different things, and she was able to rule out certain things. The next thing she did was the lack of convergence test, which is where she'd circle around his face and then bring it in to see if like he could cross his eyes, and he passed that test. So that's awesome, except that's to detect cannabis or marijuana impairment. So all it really did was rule out the cannabis or the impairment test. But then she did the walk and turn test, heel toe. He did not do well in that test. She found that he lost his balance during instructions. She used his arms for balance. He missed heel to toe. He took steps off the line. He did an improper turn, and he did stops while walking. So he thought he passed the test. Audit the Audit thinks he passed the test. But the cop didn't think he passed the test. Nevaeh says, "What's wrong?" Ooh, I have it on top chat. Hold on a second. That's a good point. Let me do live chat. Maybe it'll show up there. So mea culpa. I had it on top. It defaults to top chat. I don't know why. So he failed things, and then with the standing the one leg stand, he had a lot of issues with that, right? So you're supposed to count to 1,000 up to or 1,001, 1,002 up to 1,030. So he's supposed to do it for 30 seconds. He was not able to do that. He did say that it felt like he was standing on a boat because he blamed it on the thickness of his shoe. But she said she had to remind him several times to be looking at his toe, keeping it parallel on the ground. And while he's doing that, she's also performing the test alongside him as a visual aid. And it appeared he was having a hard time comprehending some of the instructions. He was having a hard time balancing. He was swaying while balancing, using his arms for balance. He did put his foot down. At one point in time, he almost fell backwards and was looking for the squad car, I'm assuming, as something to catch himself with. But he was able to put his foot down before losing complete balance. She says she ended the test. She didn't do the full 30-second test. She didn't want him to fall. There were 4 clues, and she observed 3 out of the 4 clues. Those 3 where he continued to have those frantic or uncontrollable body movements, whether it was his hand switching, fidgeting, or just looking around constantly. So he was showing signs of a CNS, central nervous system impairment, right? So that's what she testified to. And no one told her, no one came on to testify, that after viewing the body cam footage, that she was wrong in her assessment. So again, all we have is a cop testifying who is DRE certified. So that is an expert qualification. Whatever you think of them, a court is going to consider them to be an expert, right? A court is going to consider them to be credible, and they're going to take that person's observations and conclusions more they're going to be more compelling than a layman's. Layman probably won't even be able to testify to him, to be perfectly honest with you. And I want to point out that 2 cops came in here, Go Behind the Line and Master Sergeant Retired. They both came in here, and I asked them for their observations, and they both said they weren't DRE certified, which should give you some indication that this isn't just a joke of a certification, right? And of course, you know, the haters, the people who think that the cops are always wrong aren't going to be able to understand that. They're going to say, well, they're cops, you can't trust them anyway. So, you know, but for the non-retards out there, you should read something into that. So he's skipped all this stuff, right? Let's see what he has to say about it. Let's back up a little bit. Let's see what he has to say about it.
Mr. Moore, including a horizontal gaze nystagmus test, the walk and turn test, and the one-leg stand test. Mr. Moore,
but you
on Mr.
watch
Moore,
him
including
on the
horizontal gaze nystagmus test, the walk and turn test, and the one-leg
he's having
stand
trouble
test.
balancing.
Mr. Moore
He's having trouble
cooperated with the
balancing.
tests and completed each one successfully, with the exception of the one-leg.
So Audit the Audit says he completed each one of them successfully except the one-leg balancing test. But but completing it successfully is a misnomer. The point of the test is to give the cop an opportunity to determine whether or not you're under the influence, right? You don't pass the test. You just fail to present signs that you're under the influence, right?
Leg stand, which Mr. Moore attributed to the shoes he was wearing at the time. After completing the tests, Trooper Bozer continued with her investigation.
Can I take a pulse again? You can have a seat again.
The shoes are squishy, so.
Those are good shoes.
Yeah, they are, but they're kind of.
Pretty solid,
Huh? Yeah, these here got such a big hat on them. I feel like I'm standing on a
Do you want
balloon.
to try it with taking your shoes off?
No, I think I did get enough.
Okay. Just thought I'd ask. Some people want to go barefoot.
And Mountain Mover is now misattributing statements to me. I never said you can't deny a test. I never said that. I literally never said that. One thing that I don't like is I don't like people who quote the Bible and then lie about what I said. I don't think that's very fair, Mountain Mover. I don't think that's very fair. I don't think that's very fair of you. I don't think that's very Christian of you. And in fact, I think you should apologize to me for misstating what I said. I'll give you another couple seconds to apologize. And he did it just to trigger me, so obviously you have nothing useful. We're going to do 24 hours. Thank you for playing. Have a great day.
I feel pretty confident I passed the sobriety test.
Anything alcohol-wise today?
No.
Or in the last 24 hours? Anything in your mouth?
No.
Take your tongue out. So I get lied to every day, so let's knock that PBT out. How does that sound? Sound good? Did we have a DWI in the past before? What was that one for? Drugs or alcohol? What was that? Okay, was that your drug of choice?
Well, she already knew. So she already knew that he had a prior DUI, and so at this point, she's just fishing for stuff.
Was it your drug of choice? How did we end up using it then?
What was your drug of choice? Methamphetamine. That was his drug of choice. Methamphetamine. Why did we cut that out? Why did we cut that out? Audit the Audit. Why did we cut that out?
Okay, was that your drug of choice? How does that sound? Sound good? Did we have a DWI in the past before? What was that one for? Drugs or alcohol? What was that? Okay, was that your drug of choice? Was it your drug of choice? How did we end up using it then?
I ended up drinking some water that had it in it.
Oh.
Oh, he drank some water that had it in it. Oh, are we gonna go through all the other stuff where he would where when asked did he smoke it, did he snort it, or did he inject it? He said no, I didn't inject it. Huh? Isn't that weird? Isn't that weird? He denies injecting it.
When's the last time we used meth?
July 7th, 20.
They get a warrant. They get a warrant. She got a warrant. But states can revoke your license if you refuse tests. Yes, the DUI was a meth DUI.
2020.
2020. How often did we use it in the past? Pretty often.
Oh, when I lose my insurance from my Adderall.
Oh, gotcha.
How often did you use it in the past? When I lose my insurance for Adderall. That's a very, very non-answery answer.
Blow, 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 blow. There you go.
Oh.
Zeros. You were telling the truth. When you lose your insurance for Adderall.
Yeah, I lost my insurance.
This is where I would normally give people the advice to shut the fuck up. Like, you've got two cops there, you're gonna get arrested. Like, as soon as that second cop rolled up, you knew you were gonna get arrested. Just shut the fuck up. Don't answer questions. I mean, maybe you agree to take the field sobriety test. Maybe you don't. I mean, I'm not going to give you advice on that one, but don't answer questions. Like, you don't have to answer questions. Don't answer questions. Say, I'm taking the fifth. I'm taking the fifth. Do what you're going to do. I'm taking the fifth. That second cop rolls up. Dude, you're getting arrested. Take the fifth.
How long ago?
Oh, that's years ago. I'm going on.
Are you on probation or anything?
No.
When's the last time we used meth?
July 7th, 2020.
Cocaine?
No, I haven't used that since I was in high school.
How do we take our Adderall?
Orally, I have my prescription. If you like to see
Do you
it.
have it? Yes, I'd like to see it.
I grab my backpack, okay?
That's absolutely fine. Yep. Just, I'm going to ask you again. No drugs or anything in there?
I get drug tests. I got Class A. I drive commercial vehicles. So.
Okay. So you take this how often?
Once a day.
Once a day. So how come we have a tab and a half?
Breakfast on the weekend. I felt like taking a half tab, so I have a whole one.
Did we just take a half tab today, tonight?
So he alleges, and again, no prescription was produced at the trial. No prescription was produced at the trial. So you don't know what his prescription is. I don't know what the prescription is. And the court didn't know what his prescription is because of all the dumb fucking moves to make. If you say that I'm taking this according to a prescription, the first fucking thing you do is you provide the prescription. That's the first thing you do. You provide the fucking prescription. Guess what they didn't do? They didn't provide a prescription. So at the trial, they did not provide a prescription. I already told you that there were 5 exhibits. The state gave 4. The defendant, or the petitioner, I guess, the petitioner, Rusty, gave 1. The one that he gave was his medication list from a pharmacy, which is not a prescription. And the court even says that no prescription was given. Well, somewhere in here, it says that no, there we go. Petitioner has also not produced a prescription. Like, talk about fucking fail. Talk about fail. Joseph says the only thing found in his body was a trace of Adderall. It was a trace of amphetamine. Was it Adderall? You don't know, and I don't know. Ooh, my favorite. Hi, Aaron. How are you doing, buddy? Guess what I like to do? Guess what I like to do? Oh, yeah. God, I love doing that to Aaron. That's my favorite thing to do. Thank you, Aaron. I appreciate you stopping by. So you don't know if it was Adderall. It was amphetamine. The drug test came back. The BAC test came back with amphetamine. So there you go.
Not tonight. No, I haven't had one since this morning.
Okay. Do you have your septum? Look up.
Yeah.
Have you ever looked in somebody's nose after they snort stuff?
I haven't snorted anything in 4 years.
Okay. Just smoked it then?
No, I haven't smoked in 3.5 since.
Haven't smoked in 4 years. Haven't snorted in 3.5 years. But look, he's looking down and away. He's looking down and away. She says that is a sign of someone being untruthful. I mean, you know what would have been great? It would have been great if you have an expert testify that he's not giving signs of not being truthful. So Fletcher Boy says Adderall is on the ban list for CDL. I am shocked that he could drive with Adderall in his system. Shocked he could drive with Adderall in his system. I'm shocked that a company, he says he has his hazmats. He alleges, at least at the trial, he has his hazmats, right? I am shocked that a company would hire someone with 2 DUIs to be a CDL driver. I'm shocked because normally the insurance carrier is like, nope, we're not insuring him, nope. So I am just shocked. Don't they have to prove it wasn't, though? I don't know what you're saying. Don't they have to prove it wasn't, though? I don't get what you're saying there. The burden of proof is on the petitioner in this, because if you test, my understanding of Minnesota law, if you test with class 1 or 2 in your system, then you lose your license. That's a DWI. There is a defense where you basically have the burden of proof to show, which isn't Adderall, dummy. Adderall isn't amphetamines. Says Joseph. Whew. You know, I will take you at your word, sir. Joseph is an expert. Adderall, amazingly enough, now Adderall is not in amphetamine. Crazy. No, so basically you could petition to do for a hearing, do what's called a prescription defense. And the prescription defense is to say, yeah, you're admitting it was a class 1 or 2 substance, but the blood test already verified that. But you're saying, A, I have a prescription, a valid prescription for it. B, I was taking it according to the terms of the valid prescription. And C, I wasn't actually impaired by it. Those are the things that you have to show. So what the burden of proof was actually on him to show that he had a prescription for it. He failed to produce a prescription to show that he was taking it as prescribed, which with the half a pill makes it unlikely that he was, and you can draw inferences that he wasn't. And he certainly didn't present any doctor's prescription, or he didn't present his doctor to say that his doctor said he could take half a pill on the weekends. And there were the calls for him driving recklessly, number one, but number two, also the male trooper, he told the trooper who made the arrest, the female trooper, that this guy was jerking around, like he'd been jerking the wheel and stuff like that, like he was correcting really hard. So, which this trooper testified was a symptom of a stimulant. So I mean, he really failed to prove all three things that he needed to prove. So
July 7th of 2020.
Okay. So you're showing a lot of signs of stimulant use beyond a prescribed dosage. So I don't know if you took it at 6 a.m., right?
Yeah.
And took 30 milligrams. Yeah. You're way too stimmed out right now for that. Right. So when's the last time we actually took an Adderall pill?
6 o'clock this morning.
Okay. So what else would we have that's making you stim?
No, I don't have no caffeine, no pop. I drink bottles of water.
So again, she's talking about the looking away and looking down, as signs that he's not being truthful here.
Last time I had encounters with the cops, they were at the wrong room. They tased me six cops, tased me 12 times.
You don't fight with cops, do you?
No.
Just that once?
I didn't fight with them that time either.
Well, if you got tased 12 times, that wasn't very cooperative.
I mean, so I don't know how much of his history, his conviction history, she has. But like I said, he had a long list. I guess it timed out, but he had a long list of like disorderly conduct and things like that. Man, you're dumb. It's YOU''RE, Joseph. So good luck on that.
I was face down and got tased 12 times and put in a coma. So,
how long ago was that?
A few years ago.
Okay.
A few years ago.
So
I get nervous around cops a little bit,
I can get that. But if I ever...
So again, the nervous around cops might be an explanation for the 116 to 130 beats per minute. It might be, right? It might be. But it also might not be. And what Rusty should have done is should have produced an expert to say that actually his heart rate was in line for someone who took 30 milligrams of Adderall at 6 in the morning and blah, 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 right?
The wrong person, wrong room, wrong...
So I did dispatch. I did LTL dispatch for a moving company. And let me just say that there was no way in hell we would have hired someone with one DUI. Not hired. I mean, we would have used them because, our insurance carrier would not have done it. Like one DUI would have been more than enough to have them not uninsurable by our insurance carrier.
Wrong.
But I've never given you a reason to be nervous, right?
Well, you're telling me I'm more stimulated, and I just passed the sobriety test. And...
now you're getting agitated, which makes me a little nervous.
Am I getting arrested for DWI? Are we going in? Or what
are you going to be cooperative?
Yes, sir.
Yes, you are under arrest.
So I'm missing my daughter's graduation.
Okay, we'll try to make this fast, okay?
What do we do? Go take the drug test?
Yes, sir.
Oh, thank God. I didn't make it by 7. Oh, I guess drug test.
Okay, but the thing is, do you have somebody that can come get you? Because if I'm arresting you for a DWI...
Oh, I'll pass your drug test.
No, sir. So what's going to happen, and I'll explain it to you, is we have to go in for a BCA drug test.
So even if the drug test at this point comes back with only Adderall in his system, they still have a DWI arrest, because he admits that he had a controlled substance in him, and there's reports of him driving erratically, weaving. The male cop who's on the screen right now would have testified. He told the gal that the guy was jerking around. Staying in the lanes, but jerking around.
Which I don't get the results for today.
So I'll be overnight?
Can you just listen for 1 second? Are you going to be cooperative the entire time?
Yes. Can I grab my wallet? Can you give me
I'll grab all your wallet and stuff.
I gotta call my doctor. I'm not going to make your graduation. Oh, God.
Try to relax here, okay?
So why do you think I'm overstimulated? I don't understand.
So I'm a drug recognition.
Go behind the lines says, I can tell you exactly when I was tased over 17 years ago. Well, yeah, but you aren't a junkie. Like the guy has apparently alcohol, or at least had in the past, alcohol abuse issues and substance abuse issues, where that resulted in multiple disorderly conduct arrests and things like that. And so, his brain probably isn't as intact as yours, and he probably was high when he got tased. He probably was high, and he probably was acting up because, generally speaking, the rule is, and I know there's exceptions to the rule, but the rule is cops just don't randomly start tasing people. Generally speaking, you got to do something to get the cop to start tasing you. Generally speaking, hashtag not all. Sometimes the cops are wrong. Sometimes they shouldn't have tased you.
Evaluator, right. And you're showing signs, numerous signs of.
Like what?
Like
I took you my prescription.
You wanted that with you, right?
Yes, please.
Okay, come on back with me.
I'd like to call my mom or somebody.
Well, I'll grab your phone. I will. Okay, come on back.
Am I going to be in jail tonight?
We'll see. Typically, yes, you would be, but we're going to see how cooperative.
I'm going to pass every drug test you got. I have 0 drugs in me.
Okay, go ahead.
No pot, no.
0 drugs in you, except for the Adderall.
No coke, no meth, no nothing. Just the Adderall.
Okay, have a seat.
So this is another thing. You hear him like his emotional state. One of the things that she testifies to is that swing from emotional state to bargaining to calm to emotional to bargaining to calm. That is, in her experience, a sign that he was in fact abusing. YOUR''RE dumb. Thank you. You're doing better and better, Joe. Good job, Joe. So again, this emotional behavior is another sign that he's actually on a stimulant.
She's valedictorian?
You hear him crying?
What's wrong?
I attend set free. I go to church.
Okay, hold on, okay?
I attend set free. I go to church. Wow. Good. It's probably good for you. But I don't know, man.
I didn't have the driving, so did you see a driving conduct?
Yeah, well, he's got a cracked windshield, and then he has an inoperable passenger side brake light.
Okay.
And then, he was kind of jerky. He didn't cross over any lines when I was behind him.
Yep.
Like jerky.
Yep. Yeah, so ours.
So jerky, not smooth driving, but jerky. Yeah.
The caller had him all over.
And remember, the cop that she's talking to is also a DRE qualified cop. So.
Yeah, sure. Yeah, so his Adderall, he's not taking as prescribed. So a pill and a half.
What was it?
First one was 118. Second one was 124 or 6. I wrote it down.
Tom, no, he said he had a change of clothes in there. He wanted to get there in time to change.
35. He was fidgeting that whole time. Yeah, he was like this the whole time on his leg.
So he was fidgeting. Again, that's a sign of the stimulant.
Meth. Or Adderall that he just took way too much of. And I'm just going to document on body camera that he is not taking as prescribed. It says take 1 tablet per month per day. Over the 30 days, he got a pill and a half. What's that?
You go to my daughter's graduation. So there's been no drugs.
So even you can still get a DW.
So again, he's really upset. But then she's going to ask him to put his number into the phone, right? Or his PIN, his code. Never do that. Cops love it. Cops love it when you give them access to your phone. Why would you give them access to your phone? Never give a cop access to your phone. You don't have to use your phone to make a call. You can call from jail. Don't unlock your phone. Please, don't unlock your phone. Especially if you have anything incriminating in there, anything you don't want the cops to see, don't unlock your phone.
DUI off of a prescription medication. Okay, you're showing signs of impairment caused by the prescriptions. Even if it's not a prescription, it's a stimulant of some kind. What I am going to do for you, because you're late, you're not going to make it in time. Do you want to call somebody to let them know? I can't let you know. We have to do this process.
Please.
I'll try to get you going as soon as we can. I can't. My hands are tied.
Graduation, please.
I know.
Please.
So I'm just gonna. We're gonna get going, and we're gonna get.
I swear to God, I've done no drugs, please.
So I can't. We're under arrest for DWI.
Well, see, Cicero, it's not just like she cites a number of factors in her testimony, all of which indicate stimulant use. If it was just that he was fidgety, well, that probably wouldn't be enough. But there's a variety of things that she cites, and it's the sum total of things that they have to deal with, right?
But do you want to call somebody quick to let them know you won't make it in time? Do you want to do that, or do you want to wait?
Go behind the lines disagrees with me. He requests that everybody, in fact, I'm ignoring you. I'm ignoring you. I'm ignoring you. I'm ignoring you. Lawyers, cop, judges are not licensed to do physicals. In most states, they are not allowed to do an exam. Okay, I agree with that. Counselor, can you agree that lawyers are not doctors nor judges? Yes, that is yes. Lawyers, generally speaking, lawyers aren't doctors or judges. Hold on a second. I'm going to deal with a chicken, and I'm going to take a leak. All right. Whatever, something MD. Says most lawyers are not medically trained. They opine on things they have nothing about. Hire an expert. That was my entire thing. This whole time. The attorney for Rusty did not produce any experts. He didn't produce any experts, and so that was the issue that I'm going on about. Yes, they needed an expert, and you said an affidavit. I don't think an affidavit would have worked. This was an evidentiary hearing. Really, what they needed they need to have a expert show up to testify, right?
Okay. What's your pen? Do you want your hands, or can you go off to the
Am I
side?
going to be in jail overnight, all weekend, or what? I got to work tomorrow morning at 6 a.m.
When's our last? Okay, I'm going to ask you a question, but first I'm going to read you something, right? You're under arrest. You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to an attorney and have an attorney present during questioning. If you cannot afford an attorney, one will be appointed to you with little to no cost. Do you understand those rights?
Yes.
I'm not sure that that most people are going to have access to that. But he should have, like, if he had brought in his prescription, like, I'm sure that that the attorney for the state would have said, like, yeah, sure, okay, we'll go ahead and accept that. You know, you don't need to have someone come in and testify to it. But having a doctor fill out an affidavit saying that, you know, having reviewed this, he wasn't. Fuck that chicken. Having a doctor review it and say that in his estimation, blah blah, that is something that the state would want to cross-examine. And this isn't a case where there's a prosecutor, by the way. This is a case of where there was an attorney for the respondent, which was the commission, something of the other commission. So the respondent was the commissioner of public safety. Hold on. All right. So
now I'm going to ask you questions. I'm going to explain everything, so at least then if you answer a question, I read you that. When was your last DWI? Was it within 10 years?
2018.
19, it is 24 now. Okay, so we're within 10, so it would be a third-degree DWI. You're still not required to see a judge, okay? So I'm not going to make you sit all night, but can somebody come get you
dude, why are you crying, bro?
at 7 in the morning to get you to work? Well, you can't drive, because I'm arresting you for being impaired while driving.
I promise you, I'm not impaired.
You're impaired by prescription medication.
I drove a semi all day.
Trooper Bozer tells Mr. Moore that he is under arrest for driving while impaired by a prescription medication. Adderall is classified as a Schedule II controlled substance. Under Section 169A.20 of the Minnesota statutes, it is illegal for an individual to drive a vehicle with any measurable amount of a Schedule II controlled substance present in their body, regardless of actual impairment. This
There you go.
creates a so-called per se violation, where even prescription medications such as Adderall can lead to criminal charges.
This is a bad cop. I think you're wrong. New York Renal MD, I think you're wrong. I have seen nothing to show this is a bad cop. This is a bad attorney. The attorney for the Rusty's attorney is a bad attorney.
However, Section 169A.46 of the Minnesota statutes creates an affirmative defense, which allows drivers to avoid a DWI conviction if they can prove by the preponderance of the evidence that they used the controlled substance according to the terms of a valid prescription.
Well, that's one part of it. They have to show that they have a valid prescription. Number two, they have to show they used it according to the valid as prescribed. And number three, even if they use it as prescribed, even if they have a valid prescription, they still can't operate a vehicle if they're impaired. If they're actually impaired, then it doesn't matter that they have a prescription for it. And New York Renal MD, you say that she doesn't even know what a DUI is supposed to be. Well, now you, sir, are doing what a lot of very educated and smart people do. And that is to think you know things you don't know. You're not a cop. You're not trained as a cop. You are assuming things about what DUIs. You're not even an attorney. You are assuming things about this based on your experience and your knowledge, but you're not an expert on it. You're probably, I'm assuming that you're a doctor. You're probably an expert at being a doctor. And if you're a renal MD, that would be what, a kidney? So you're probably an expert at any issues with kidneys. And you could be called upon to testify about that. What you could not be called upon to testify about is whether or not it was a good DUI stop. Congratulations, New York Renal MD, but you're not qualified to testify about what a cop does or doesn't do.
Issue with this defense in Mr. Moore's situation is the presence of the half tablet in his prescription bottle when the terms of his prescription were to take 1 pill per day.
Well, no. So you got to remember, see, he's wrong. Audit the Audit is wrong here. It's an affirmative defense. And what that means is that unless you raise it, it doesn't have to be considered. So what the cop says is, great, you've got this, congratulations, you're still not a cop, dude. You're still not a cop. All right, so the issue is you get arrested for it because the cop can prove that you have the drugs in your system, or that he has probable cause you have the drugs in your system, and then the test proves it. An affirmative defense is then raised. It's something that isn't just implicit in there. Like it's not like it's not like the cop had to take into consideration whether or not there was a valid prescription. The cop didn't have to consider that. What the cop had to figure out is, do you have a class 1 or 2, a schedule 1 or 2 drug in your system, even probable cause that you have a class 1 or 2 scheduled drug in your system, a stimulant. And based on that, the cop can make the arrest, right? And so if the cop makes the arrest, then the lawyer can raise the affirmative defense, right? And in order to raise, and what that means is it shifted the burden of proof. The cop's burden of proof is just to prove that you have the stuff in your system, right? The BCA test comes back, you've got the stuff in your system, case closed, problem solved, we're good to go, right? the affirmative defense is a shift of the burden of proof. Now the petitioner, in this case Rusty, has the burden of proving that A, I have a prescription. Okay, well, how about this? How about this? How about you stay in your lane, because we're talking about what I know about and not what you think you know about. So the petitioner has the burden of proving by a preponderance of the evidence that he had a valid prescription, that he was taking the prescribed drug in accordance with the prescription, and finally that he was not impaired. He was not impaired. That it did not impair his driving. So there's three things that the petitioner has to prove by a preponderance of the evidence, not to the state. Okay, so that's where Audit the Audit is getting this entirely wrong. That's nothing. None of that is anything that the state has to prove. None of that is.
Although Mr. Moore explained to Trooper Bozer that he sometimes only takes a half tablet on the weekend when he does not have to work, Trooper Bozer later testified that she did not believe this explanation, and that instead she suspected that Mr. Moore had crushed and snorted Adderall after work. It should also be noted that the prescription defense only...
So she did not believe that he only took one pill at 6 in the morning. She believed that he took an additional half a pill when he got off work because of the presence of the half pill in the bottle.
Only applies to a so-called per se DWI charge based on the mere presence of a Schedule 1 or Schedule 2 drug in a driver's system.
Right. So that's why he would have to show the prescription, that he took according to the prescription, and that he wasn't impaired. If he was actually impaired, well, then the prescription defense doesn't apply. The problem is that there is a witness who called it in, and that witness is presumed credible because the witness gave identifying information. And the other DRE officer observed the jerking behavior. Paige says, why did she think he snorted it? That's ridiculous. My doc tells me to take half pills all the time. Well, Paige, you probably have a prescription that says that. His prescription, according to him, does not.
It does not apply to a charge of being, quote-unquote, under the influence of a controlled substance, which is also prohibited by Section 169A.20 of...
And that's the issue. They think that he, number one, well, I don't think, I think the cops probably assume that he did have a prescription. I think the cops assume that. You got the pill bottle, it's got your identifying information on there. You know, New York Renal MD thinks that we can't interpret a prescription, but you could read it. You can say, okay, it's this person, it's this amount, you know, take orally once a day at 6 a.m., whatever, with food, without food, whatever it says, right? You could get enough of an idea to think, yeah, it's probably his prescription, right? So I'm sure the cop thought he had a prescription, but what the cop thought was that he was actually under the influence, that everything about him, about the interaction, was that he was under the influence
of the Minnesota statutes. In other words, having a prescription is not a defense.
He did not show a valid prescription, Page B. He did not show one. I don't know whether he could or couldn't. I'm shocked that they didn't present one. But it's their burden of proof. It was Rusty's burden of proof to present the prescription, because that's one of the things he had to prove.
If the prosecution can prove.
So they don't need Paige to prove that he snorted it. He could have taken it orally. It's her assumption that he snorted. That's her assumption. And her assumption is based on he's acting too stimmed up for having taken, in her experience, as an expert, as the best expert available at the trial, in her experience as an expert, DRE expert, that he was acting too stimmed up for having taken one 30-gram pill at 6 a.m. So the explanation, an easy explanation would be he took an extra half a pill. And because of his prior answers about injecting or snorting, she did actually ask, you know, if he injected. He did show his that they didn't have track marks. So she's like, oh, you must be, you know, just it's an assumption on her part. She didn't have to prove it. That's not an element that she has to prove. All she had to do was by preponderance of the evidence, or by probable cause, to get the warrant, to get the blood test, right? And then once she's got the blood test comes back, Schedule 1, Schedule 2, that's enough right there. He loses. Unless he asserts an affirmative defense. Unless he asserts the affirmative defense. So he could have, only, like, let's say he only took the one pill. Let's say he only took his prescribed amount. If that impaired him, then it doesn't matter.
Prove that the driver was actually impaired by the drug, as the law expects prescription users to refrain from driving if the medication affects their ability to drive safely. Therefore, Mr. Moore could potentially be found guilty of DWI if he was found to have taken his Adderall outside the terms of his prescription, or if the court concluded that he was actually impaired by the Adderall.
Okay, but I'm just telling you what you're under arrest for, and what I see are the signs of impairment. I
ran out of my Ozempic yesterday. My blood sugar's probably high.
Okay, so even that's not going to cause what I'm seeing. And we can...
Okay, explain to me slowly because I'm retarded. How can what someone tells a dispatcher that tells a cop about someone's bad driving and getting over the hearsay rule? Okay, so it wasn't introduced as evidence, Dan. It's not introduced as evidence. It is information, though, that the cop can rely on. If they had to prove that he had actually crossed the line, inadmissible, completely inadmissible, hearsay, done. But the cop can rely on that because it's credible evidence for the cop to rely on to make a determination about probable cause. If it is a identifiable caller, at least in Minnesota, right? At least in Minnesota. Rich people don't lose these cases. They do. They can. I mean, didn't Nick Rekieta lose a very similar case? I think he did, and that dude inherited money, and he's an attorney, and he spent a shit ton of money on his defense, and he lost. So yeah, they do. Merb Kevin can't answer my question now. Well, he could DM you or whatever. All right.
You can have the hospital check your blood as well. But
You're not going to find nothing in my system other than my Adderall, and you're not going to find a high level of it. You're going to find it within normal range.
Okay, then that's what we're going to find.
Then why offer that irrelevant info about snorting? People add irrelevant info all the time. Most of the things in this are irrelevant to the actual case. There's only a few relevant things. I think that lady cop likes anal, but that's just my assumption and irrelevant. Yeah, that is your assumption and irrelevant, and I think it's projection, which makes me like you even more, page B. No, he got convicted. His wife took a plea, I believe. Wait, did he take a plea? I thought he got convicted.
Oh, I still get DWI out of that?
You're under arrest for
I'm not losing my CDL.
Well, either way, plea deal or found guilty at trial, it rebuts Joseph's rich people don't lose these cases statement.
Well, for this or what?
So this is one.
It's my job.
I know. So the blood doesn't come back for like 2-3 months. So everything stays as is for 3 months. Then you can take it to court. You can fight it in court. You can do whatever. But that's the process that goes.
How long will it take for you to release me? I can't drive my car out of here.
Absolutely not. I just arrested you for a DWI.
I'm not going to make a graduation.
No, we're not making a graduation tonight. And we try to make this as fast and smooth as possible.
It's heartbroken.
I know. So move in the end, okay?
Drugs, I've done nothing
Okay.
wrong.
So you didn't want to give me, they didn't want to do the passcode for his phone, which also tells me. Yeah, I'm going to see who they have for a tow. Okay.
This one hand is going numb, ma'am.
Which foot? Which hand?
This is my right hand.
Okay, let me take a peek at it, okay?
So, I mean, she's nice enough to loosen up his cuffs, right?
Okay, so I'm going to lock it so it doesn't get any tighter than that, okay? Hold the spacing on
I
that.
promise you I've done no drugs.
Have a seat in there, okay? Is that better?
Yes, thank you.
You're welcome.
I have a bottle of water in my backpack. Can I get that by chance?
Yeah, I'll grab it. But we can't have it until after we do the blood.
Okay.
Just because, like we said, we've already drank meth before, so I'm going to make sure there's...
Is there any way we can hurry that up? Because maybe I can hitchhike and make it there in time.
We'll try to figure something out. Just hang tight. So he's got mood swings. He'll start crying, stop crying.
Can you grab my clothes for the graduation?
I don't think we're going to be there in time. Okay, I'll go look. He wants his graduation clothes just in case. Okay, he'll be Just tell them the stuff's on the dash. And then if you want to even come to the hospital, call pending, doesn't matter.
So what's going to happen? What's it look like?
Yeah, thank you, Reaper, but that's not really pertinent. Even if you took a plea deal, it still rebuts Joseph's statement that rich people don't lose these cases. Rekieta is rich. Rekieta lost. By plea or otherwise, he still lost. Irrelevant information. But thank you. Thank you for wasting everybody's time with irrelevant information.
So now we go in, I type a search warrant, they'll take blood, and typically you'd go to jail for the night. But we'll see.
After his arrest, Trooper Bozer obtained a search warrant, and Mr. Moore agreed to a blood draw. The sample was tested by the Minnesota
There you go.
Department of Safety Bureau of Criminal Apprehension, which found the presence of amphetamines in the amount of 0.034 milligrams per liter, according to an expert retained by Mr. Moore in his defense.
Well, according to an expert retained by Moore in his defense, this letter, whatever it is, was not presented at trial. So that's a big oopsie fucking doodle. And this guy never testified at trial. And this guy was never mentioned at trial. None, like, where did we get this from? None of this. Where is this from? Joel Albers. Let's look up Joel Albers, PhD. There we go. Hold on a second. PhD PharmD. Okay. So he was a clinical pharmacist at a walk-in clinic. And he does the, so he probably would be a good expert. Probably would be a good expert. The problem is that he didn't testify, and this didn't make it into evidence. So that's a problem. So again, I don't know. I don't know if if this is a failure of the attorney or what. I just don't know. Like why wouldn't you have presented this at the trial? Why wouldn't you have submitted this? You know, I would have at least submitted it, even if I couldn't get this dude to testify. I would have at least submitted it. Like, just like, I can't get this guy to testify, Your Honor, but here's an affidavit. You know, the court would probably or opposing counsel would probably object to it as hearsay, and it probably wouldn't be considered. But I'd at least try, right? I would at least try. So, you know, I just don't. I don't know what to do. I don't know if it is consistent, right? So it's a problem. It's a problem. But this guy did not testify. His name was what was it? It was Joel Albers, Albers. So Control F, A, L, B, E, R, S. Nothing. He's not in there. If you didn't believe me, he's not in there. Like, I don't know what to tell you. So is Rusty innocent? I don't know. I don't know. Is Rusty innocent? I don't know. Did he definitely fail his burden of proof? Absolutely. You know, absolutely. Is that his fault, or is his doctor's fault, or his attorney's fault? I don't know. So,
This amount is within the so-called therapeutic range of Adderall usage and was
and if this pharmacologist or whatever, if he had actually shown up and testified, his testimony would have been the only testimony about whether or not the blood level for Adderall was in the therapeutic range. It would have been the only testimony. They asked the cop, is this the right amount for this range? And no one knows. No one knows, right? But if this guy showed up, he would be the only one. It would be fairly easy to qualify him as an expert, I think. And 19 years of experience, that's a lot of experience as a pharmacologist, right? As a clinical pharmacist, whatever. I assume that you'd be able to no, Paige. They had the potential for witnesses. The state called the trooper, and Rusty called himself as a witness, which I don't know why he bothered, but all his attorney likes to point out the things that Rusty said, and we got to remember what I've said so many times. Anything you say can and will be used against you in a court of law. Nothing that you say is really going to fucking help you. Period. Which is why you shut your fucking mouth. Generally speaking, I don't think that people help themselves by testifying. Generally speaking, I disagree with other attorneys who think that usually you help yourself by testifying. I disagree. I don't think that it's very. I don't think that it's a very good idea generally. But there's like Rusty wasn't an expert. He couldn't. All he could testify to was like the things that he knew. Like, I only took the one pill in the morning. I didn't take a pill after that. Blah blah blah.
consistent with his prescribed dosage of 30 milligrams daily taken at 6 a.m. Mr. Moore was charged with 2 counts of DWI, 1 count for driving under the influence of a controlled substance, and 1 count for driving while his body contained any amount of a controlled substance. As a result of his arrest, Mr. Moore lost his job and his commercial driver's license was revoked. He retained legal counsel, who filed a petition for judicial review of his license revocation. On October 31st, 2024, the court denied the petition, and Mr. Moore appealed the decision to the Minnesota Court of Appeals. Oral arguments were held on June 3rd, 2025.
Here's a fun fact. It's gone. Now, I have a copy, by the way. I do have a copy of the oral arguments. I don't think there's anything terribly interesting in there. I downloaded the oral arguments on my phone 5 days ago. So on the 30th, 31st, 30th, on the 30th, right? So they were there, but now they're not. And I could even prove it to you. Let's go here. And we're gonna go here. Oop, I didn't want that. I want oral arguments, and then archived oral arguments. Now, if we do the 1896, they couldn't find it, right? But if you do Rusty. Not a lot of Rusties out there in the world. You find it, right? So here it's Rusty James Moore, petitioner, versus the Commissioner of Public Safety respondent. But then it's a wrong case number. It's a wrong case number. And if you actually try to listen to it, it has see Rusty up here, Rusty James Moore, petitioner. But down here, the case name is the Presbyterian Family Foundation on behalf of whatever, however you say that. So I don't know what happened to it. I don't know where it went. I do have a copy of it. It wasn't that interesting. Rusty's attorney, I don't think, did a great job. He has a real hard time. He's got a long road to hoe. He didn't provide a copy of the prescription, so that was not adduced into evidence. He did not. Well, the court may or may not believe that Rusty took it on the day of the arrest according to prescription, but he also might think he didn't, right? Because there is evidence that the half a pill is strong evidence that he in fact does not take it according to prescription, right? So even if you assume that there was a prescription for 130 milligram a day, no prescription was produced for that, but also no prescription was produced for a half a day or half a pill on the weekends. So there's just no Bad Apple Media. You got to remember, Tube Sock is a troll. Just relax. He's a troll. Like he literally just does this to rile people up. I don't remember. Oh yeah. So but the that attorney didn't have a very strong appeal, I don't think. The state has a much better position on the appeal. First of all, generally speaking, the appellant loses. The second reason why is because there was no expert. Again, if Rusty had produced an expert, they would have testified as to what the blood level should be, etc. That would at least have gotten him the first two steps in the prescription affirmative defense. But the prescription affirmative defense only applies if he was not impaired, and there is evidence that he was in fact impaired. So what are you going to do? You know, that's a problem. That's a problem for him. So we'll see how he deals with it.
And as of the date of writing this episode, both the Court of Appeals decision and the criminal charges against Mr. Moore are still pending. Mr. Moore is seeking a civil...
The criminal charges are still pending? What pending criminal charges?
And as of the date of writing this episode, both the Court of Appeals decision and the criminal...
I didn't see that on there. Interesting. Was it James, I think? That doesn't show up on this. Interesting. Interesting. So we'll see.
Charges against Mr. Moore are still pending. Mr. Moore is seeking a civil rights attorney and has started a GoFundMe campaign to assist with the costs of legal representation. I've included a link to this campaign in the description below. Overall, Trooper Bozer gets an F for
See, why does she get an F? I don't understand this. How does he give her an F? I guess he'll explain it. But she was polite. She didn't use any force. And he got convicted. So, or not convicted. He got his license suspended. So I don't understand. Like, what right of his did she violate?
Demonstrating inexcusably poor discretionary decision-making by choosing to arrest Mr. Moore, praying...
Why was that inexcusably poor decision-making? There was ample evidence that he was under the influence. And he, in fact, was under the influence. Whether or not he was under the influence to the extent where he couldn't control the vehicle, well, there was evidence that he couldn't. I have said this before, and I get a lot of flack for it, but I don't think that DUI, DWI should be a standalone offense. I don't think it should be, right? I don't think if you haven't committed a traffic violation, my opinion, if you haven't committed a traffic violation, then it shouldn't matter. Like, I don't think it should matter. I think a lot of times a lot of times cops will use it as a pretext stop. But if you look at the background of all the things, he has a history of drug abuse. He has multiple DUIs. Someone, as a prank or whatever, called it in. Called in him doing erratic lane changes and everything. Like, if you look at the sum totality of the facts, they definitely had probable cause that this dude that he was in fact violating the DWI laws in the state. Whether or not there should be those laws is a different story. I don't think there should be, but the fact is there are DUI laws, DWI laws in Minnesota, and there's ample evidence that he in fact was violating, right?
On Mr. Moore's lack of legal knowledge and the pressing circumstances at hand, and for maintaining a completely unwarranted accusatory tone throughout the interaction.
An unwarranted accusatory tone, except he actually did have class 1 or 2 or schedule 1 or 2 drugs in his system. Like what?
The legitimacy of Trooper Bozer's arrest is certainly in question, but
it is absolutely not in question because he lost his license, because he actually had the drugs in his system. Like, what expert stood up and said, you know what, she actually didn't have probable cause? What court has found that there was no probable cause? You show these as pending felonies. You show these as pending felonies.
In this episode, both the Court of Appeals decision and the criminal.
These are pending felonies. No, I'm sorry, misdemeanors. So I'm going to go out on a limb here and suggest that there is going to be a probable cause hearing, or there has been, considering it's from a year ago plus. There had to have been a probable cause hearing at some point. Let's look at this up. Case number 24 CR-24 CR-24 49 CR-24 1688 1688. Well, interesting. Here we go. Here we go. Case status is open. Oh, he took pretrial diversion. That looks like he took pretrial diversion. Oh, I guess not. All right. So it looks like they're waiting for the appeal to get resolved before they resolve this one. But again, good luck to him. Good luck to him. Let's see. We got another hearing. So they have an omnibus hearing. Gotta love them omnibuses. To see what they can resolve on September 4th of 2024. Interesting. So we'll see. So there had to have been a hearing. There was a hearing held, and then that, yeah. So there, this was the this was probably their probable cause hearing. Probably the probable cause hearing, because that's when apparently he pled and got the bond conditions. So.
Lack of legal knowledge and the pressing circumstances at hand, and decision-making by choosing to arrest Mr. Moore, preying on Mr. Moore's lack of legal knowledge and the pressing circumstances at hand, and...
See, I don't know really. He shouldn't have talked to the cops, but talking to the cops didn't do it. Right up to the point where they had contact. Or excuse me, right from the point where they had contact. Both the cops thought he was abusing stims. So, I mean, I don't know if it would have helped.
For maintaining a completely unwarranted accusatory tone throughout the interaction. The legitimacy of Trooper Bozer's arrest is certainly in question, but her...
Oh yeah, and so she did get a warrant, which is probable cause. So there was already probable cause for the warrant, right? There's already probable cause for the warrant. So Audit the Audit is wrong again, because she got a warrant, and she had to show probable cause to get the warrant.
Complete lack of empathy for Mr. Moore's situation is the most...
And cops don't need empathy. That's like... You're not a very empathetic cop. If someone has a good enough sob story, you should just, ignore the laws? You should just not enforce them? That's so stupid.
Most troubling aspect of this encounter. Mr. Moore took a medication that was prescribed to him by a doctor, and ultimately...
Allegedly he did. So again, if the criminal trial is still pending, then we'll wait and see. He alleges he took one, but he didn't show a prescription at the implied consent hearing. He alleges he did it, but he didn't provide a prescription. He alleges he took it according to the prescription, but there's a half a pill, so it's an allegation. It hasn't been verified. None of it's been verified, and you don't know what, if anything, in excess he took. So all of this is allegations. It's going to get proven at trial, but it's you're just dumb, and I don't understand. I don't understand Audit the Audit. He's so fucking stupid. None of this is smart.
He ended up being arrested.
So yeah, they have a double thing. If you don't agree to it, they won't take it, but essentially it's used against you. So you have to get permission, plus they have to get a warrant. So there you go.
Arrested, missing his daughter's graduation, losing his job, and being forced to deal with the legal aftermath of his arrest. Trooper Bozer didn't take any of that into consideration before.
But that's not she's not the judge. She's not the jury. That's not her job. Her job is to arrest people that she thinks have violated the law. That's her job. She arrested somebody that she thought violated the law. And it appears he did. So what are you going to do? I haven't seen any exculpatory evidence other than the assertions made by Rusty. So there you go.
Affecting her arrest, and she relied heavily on Mr. Moore's past as an excuse for her conduct. Remember?
Well, no, that's not evident from her transcript. Before she knew his past, when she walked up to the window of the other cop's car, she was under the impression that this dude was abusing stimulants. That was the impression she was under. So she didn't know his past then. Then she asked the guy, does he have any DUI? Oh, yeah, he got convicted of DUI in 2012 or 2021. So, I think you're wrong. I don't think the evidence supports your assertion.
Members of law enforcement have the discretionary authority to arrest, meaning they can choose whether or not to make an arrest based on the facts associated with each individual encounter. Here, it is clear based on the video, and later proven by the blood test, that Trooper Bozer could have exercised her discretion not...
It wasn't proven by the blood test, because remember, any amount of a Schedule 1 or 2 in the bloodstream is a crime. Any amount. Now, if he's not impaired, he just has it in his bloodstream, then the prescription defense becomes available. You missed that class. Go behind the lines. Go behind the blue line.
Not to arrest Mr. Moore, as he was obviously...
So Paige says, I'm sure she's a twat. Yeah, you would think that because you're anti-cop. But she was not mean at all during this. She was not mean at all during this. I thought she was very pleasant. I thought she did her job very professionally. I'll call out a cop if I think that cop is is being an asshole for the sake of being an asshole, but I didn't see that here. And if you did, that says more about you than it does about the cop.
Not dangerously impaired, despite a national decline.
Not dangerously impaired. You see how I slipped in that qualifier there? What does dangerously impaired mean? Does that mean weaving between the lines? Does that mean crossing the lines when you're weaving? Do we have to completely ignore the report of the concerned citizen? Like, what does dangerously impaired mean? And what we're gonna look at DUI arrests for a DWI. Oh, this will be fun.
Decline in DUI arrests over the past.
Yeah, see, but this is a DWI, not DUI. So there you go.
Decade. False arrests remain a serious and underreported issue. In Tennessee, investigative reports revealed that more than 600 individuals arrested for DUI between 2017 and 2023 later tested negative for both drugs and alcohol, which led to
Okay, 600 over the course of 6 years, 100 a year. How many arrests were made in those years for DUI?
legislative calls for reform within the Tennessee Bureau of Investigation. Similarly, in Honolulu, a class action lawsuit filed by the ACLU exposed that at least 127 drivers were arrested between 2022 and 2024, despite recording 0.000 BAC levels. With most.
So, for an arrest, remember, for an arrest, all that you need is probable cause. A crime was probably committed, and you probably committed it. Innocent people get arrested all the time. That's because we're humans. Humans aren't perfect. Humans aren't perfect. So humans aren't perfect, right? So the way that we do this in the U.S. is if you have probable cause, you can make an arrest. Probable cause, make an arrest. Probable cause, make an arrest. Guilty or innocent? Nope, that's not in the consideration. Probable cause, make an arrest. Yes, but remember, you have to agree that one innocent person arrested is unacceptable. It's not. It's absolutely not. Like, that's welcome to an imperfect human system. It's not unacceptable. It's less than perfect. That's all I could give you. It's less than perfect.
Most never formally charged. These cases suggest a troubling trend of preemptive arrests made without sufficient probable cause and raises concern.
Show me where a judge has found there was insufficient probable cause.
Concerns about systemic failures and possible quota-driven enforcement practices. This interaction highlights exactly how these cases happen and the real-world devastation they can create. As for Mr. Moore, I cannot rightfully assign a grade to an individual who did everything within their ability to avoid being arrested, but was nonetheless a victim.
Everything except maybe abusing prescription medications. Maybe. I mean, we don't know. Like, why don't we fucking wait until the trial's over? Why don't we wait until perhaps we get an expert on the stand who can actually testify to these things?
Victim of systemic failure, poor training, and a complete lack of compassion. Although it would likely have been within his best interest to refuse taking the field sobriety tests, Mr. Moore was doing whatever he could to expedite the encounter so that he could attend his daughter's graduation.
Well, great, but that doesn't address at all whether or not he was impaired. He's failing. Audit the Audit is continuing to fail to address the call from the concerned citizen. Like, I get it. That concerned citizen might have made a mistake, but then it was corroborated to an extent by the cop who got behind him and said that he was jerking around. That quote earlier. So there's a difference between arrest and conviction, and what they're talking about. What Franklin, I've heard it ascribed to various people. That particular quote is that we want to set up our system so that it is harder to get a conviction than easier, so that it's much less likely that you're going to get an innocent person convicted, and but the unfortunate side effect of that is it's harder to convict a guilty person. So our system is set up that to get a conviction, number one, it's supposed to require proof beyond a reasonable doubt, which is hard to get. And you're supposed to have that by 12 jurors. You got to get 12 people agreeing beyond a reasonable doubt that you did the thing. And we have all these rules, evidentiary rules in place that keep out evidence that might otherwise be very damning. For example, if you get evidence in violation of the Fourth Amendment, it will most likely get excluded, even if it's very damning evidence, even if it's incredibly damning evidence. Like if the cop, like, let's say for example, the cop doesn't have reasonable articulable suspicion for a Terry frisk, but he does it, right? And he reaches into your pocket and he pulls out a baggie of crack, right? Well, he probably violated the Fourth Amendment by doing that search, and that baggie of crack will probably get excluded from evidence, and so and the fruit of the poisonous tree will probably get the subsequent things excluded from evidence, like blood tests or whatever, and so that guilty person will most likely go free. That's what our system is revolves around. But probable cause is just a crime was probably committed, and I think you probably committed. Very low standard. You catch a lot of fish in that net, and it will catch innocent people in it.
It is not always practical
to... So Paige asks a stupid question, so let's answer it, because she has big tits. She says, how does jerking around or having dry mouth or being under the influence of Adderall automatically mean he was impaired? It doesn't. It doesn't. It is evidence that he was impaired. It doesn't mean he was. It's evidence he was. That's it. It's just evidence that he was. She says, without the caller's testimony, the cop didn't witness impaired driving. The caller's testimony goes to the stop, the probable cause for the stop. And it adds weight to the jerking. So at trial, the other officer for the actual crime, the other officer will most likely testify as to that, as what he witnessed, the jerking around. But I'm glad you're an attorney now. So good job on your attorneying, Paige.
to take the most prudent legal steps available.
You do way better drinking on camera than you do being an attorney.
Available during a police interaction, especially when they are unexpected, like most traffic stops are. Mr. Moore's primary mission at the time was to attend his daughter's graduation, not ensure that his...
Well, I don't know. Why does his motive at the time for driving, why does it have to do anything with this?
His constitutional rights weren't violated. Mr. Moore was as compliant as he could...
Show me where his constitutional rights were violated. I'll wait. Audit the audit. Show me where his constitutional rights were violated. That's an assertion that just came out of nowhere.
Possibly be, but that didn't save him from being arrested, missing a once-in-a-lifetime event, and then having to deal with the subsequent legal fallout that is still ongoing to this day.
Yeah, well, you know, what if it gets proven in court that well, it doesn't. I mean, he admitted that he had Adderall in his system. So, what if it gets proven in court that he was driving erratically? He was jerking the wheel around. What if that gets proven? Then what?
If Mr. Moore had refused to take the field sobriety tests, well, then he would likely have still missed his daughter's graduation, but at least he wouldn't have provided the state with evidence that they could use against him later.
Well, so, yeah, but if they had probable cause for the arrest, they had probable cause for the arrest. I mean, that if you agree that they would have still had probable cause for the arrest, audit the audit, then they would have had probable cause for the blood draw, and the blood draw would show the effect of, or show the presence of it, and now he'd still have to overcome A, showing the prescription, B, showing that he used the drug in accordance with the prescription, and C, that the state would have to prove then that he was driving impaired. If he shows the other two things, then the burden is still on the state for them to show that he was actually impaired driving.
While I completely understand why Mr. Moore chose to participate in the field sobriety tests, this interaction demonstrates how blind...
For a self-proclaimed SCOTUS clerk, ATA sure gets a lot of basic legal axioms totally wrong. The clerks for the Supreme Court are attorneys. I'm going to 100% guarantee you that Audit the Audit's not an attorney. Let me rephrase that. Elon exists. Let me just say that I guarantee you that Audit the Audit is not a SCOTUS clerk, because a SCOTUS clerk is an attorney. It's a prestigious position. The best of the best go there. And Audit the Audit is way too fucking stupid to. So he's not. I just guarantee you he's not. I would defy you to show me any credible evidence that he is a clerk for the Supreme Court of the U.S. Any credible evidence.
Blind compliance and uninformed consent can carry serious legal consequences. I wish Mr. Moore the absolute best in his case, and I will leave a link to his GoFundMe campaign in the description below if you're interested in helping him find representation. Let us know if there's an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't...
What a piece of shit. Anyway, so that's what I got for you. I appreciate you watching.